Well, let's discuss this further. A legal practitioner joins us in our Lagos studio, Mr. Sonny Awonaga. Thank you so much for joining us on the program.
Thank you for having me on the program. Good afternoon.
All right, just before we go to the $9 billion court judgment, let's talk about the NBA. Day two yesterday appeared really interesting. Some people called it a stormy session. But looking at the outburst of the Senate Minority Leader, what was supposed to happen?
I was actually correct, and like you could see, a past president of the association, that's Olisa Agbakoba, said he was very happy that at least he reminded members of the bar about the truth of the occasion. What Mr. Femi Falana said, for instance, to me is his own opinion. You don't, there is this presumption of innocence which you have in the Constitution. It is immaterial whether you say Mr. A declared this, he declared this, or he didn't declare that or not. But what we are saying is due process must be followed. There is a Constitution, and at all material times there should be no exceptions. Nowhere in the Constitution would anyone expect the Code of Conduct Tribunal to say it's instructing someone, whether the president, to remove a sitting CJ. There is no such thing in the Constitution. So the senator was right on point when he mentioned that, and that's why you could see Dr. Olisa Agbakoba, who said, well, he was very happy that at least for the first time, somebody was telling members of the bar the truth, even outside the bar. So clearly the Constitution was infringed. It's just unfortunate that most of these things, they had a political undertones to it. But the truth there is that the Constitution was breached as regards the removal of the former Chief Justice of the Federation.
Do you think members of the bar and the bench should be a little bit more aggressive when it has to do with issues that affect them?
No, it shouldn't be about them alone. Anytime there is anything that appears to be an infringement on the rule of law, I think we as members of the bar, we should rise up to the occasion. Even the Attorney General is said to be the leader of the bar. We should expect these things to happen. But regrettably, that's why till tomorrow you see people championing the cause that there should be a separate office for the Minister of Justice, a separate office for the Attorney General. In other climes, you can see an Attorney General indicting a sitting president and nothing will happen. But it's different here because his loyalty is primarily to his appointee.
Let's go to the $9 billion court judgment, UK court judgment in Nigeria. Several issues have come up, and the federal government is has taken a position on that as well. I mean, as a student of arbitration, I know that we have hearing on liability, quantum, and enforcement, and this is what we've gotten, the one on enforcement. But in trying to get our acts together, is there still a valid argument that we can bring an appeal before a court or tribunal?
I think all these things, they are what we call a wishful thinking. Because it's a question of a stitch in time, saving 9 stitches. Once you have an agreement, you have an agreement. It is immaterial whether it's imperfect, all that. The duty of the court, they will always tell you, even a day-old student at the bar will tell you, the duty of the courts is to interpret contracts validly and willingly entered into by the parties, not to make a separate one for them. Now, all these arguments they are bringing, you ask yourself the question, when there was arbitration, where were these arguments? Are they just realizing Nigeria is a sovereign nation? Are they just realizing the NNPC wasn't involved? So all these things, they are more or less afterthoughts. It's like medicine after that. At the point that there was arbitration, they had a duty to canvass all these arguments, but it's not after the arbitration is in place, then you go, you lose, then you start bringing all ingenious arguments. It's just a function of time wasting. No matter how long, you can only try to delay, but at the end of the day, I don't see any light at the end of the tunnel, because the bottom line was that, fine, the agreements were poorly negotiated, poorly drafted, maybe the then AG didn't vet it, but the truth is that the agreement was in place. These things should have been canvassed at the arbitration, not after all has been done. It's an afterthought. I don't see any way out. Sooner than later, we'll end up paying this sum.
Many people have also talked about how, it's gone through a few governments, and we know that, I mean, government is supposed to be a continuum, but they've also talked about the attitude of local contractors, that these are some of the things local contractors face on a daily basis when we have one government, and before you know it, they change their contract and they have new governments cancelling the contracts. But, going forward, what can we do? How can we salvage this? Can we minimize the cost? Exactly.
The way it is, I think I wouldn't know the intention of those who are at the forefront, because if you look at this when it's happening, there was a time they said they changed legal thing. You see different kinds of ingenious arguments being created by the day. Oh, today is a sovereign nation. Tomorrow is London shouldn't have been a state of arbitration. All sort of things. But I think common sense can still prevail. You can still call the judgment creditor. That's the guy. Call the person to the table and try to whittle down There's some, because I don't see us escaping out of this. To the extent that we submitted voluntarily to arbitration, that's where the problem is. Had even we contested it, it would have been a different ballgame. You can't blow hot cold. What we call it, you can't appropriate and interpret. You can't sit down and agree to be bound by the outcome of arbitration. Supposing we had won, will we be complaining? No. So that's why the only thing we can do is to try and see whether the same person who is victorious, whether we can call them behind closed doors, seasoned negotiators, sit down there and try to bring down this thing. Because there was a time they said they were able to negotiate for 850. But maybe they felt, oh, they wanted to bring it on, but nobody followed it up until the present mess we are in, 6.6 billion, now it became a 9 billion. But there is still a solution. Right. I'm sure with seasoned negotiators and international lawyers, one way or the other, we can still bring the liability down. But the thing we can escape liability is just wishful thinking.
We'd like to appreciate your time on the program, Mr. Sonny Awunuga. We'll take a short break now. When we come back, we'll look at the challenges of election collation in Nigeria. Please join us again.